Howdy, my name is Brian Foley. I am here today talking to you about Texas Rule of Evidence 407. I'm a criminal defense attorney, board certified in criminal law, and I practice in Conroe and Houston area. So let's talk about Texas Rule of Evidence 407. It is the subsequent remedial measures rule. And what it means is that if some business has done something or some company has done something and then they change their business practice because they want to do something a little bit safer. Well, let's take steps in front of a store. If the steps get icy, an old lady falls, breaks her hip, and then from that day on, the day of that incident, they start putting salt on the stairs every morning when it's icy. Well, that would be a subsequent remedial measure. It's something that that company is doing differently to prove that or to make things safer for their customers. Well, that's great evidence to show that they should have been doing that all along and they were negligent in not doing that. So they should owe money damages to, the old lady for falling and breaking her hip. Well, you can't admit that into evidence, the fact that they're doing this now in the trial for the old lady. Why? Well, it's a practical matter. If we allowed plaintiff attorneys to do that, to introduce those subsequent remedial measures, then businesses would be discouraged from making their place safer for future people, right? You would say, as the lawyer for the business owner, well, you could start salting these steps every day, but if you do that, then the plaintiff's attorney is going to use that to show that you were negligent. You should have been doing it the whole time. You see what I'm saying? So, as a policy matter, we have this rule that says you can't do that. And then let's look here at the language of the statute. Okay. Here's what we're looking at as far as the language. It says when measures are taken that would have made an earlier injury or harm less likely to occur, evidence of the subsequent measures is not admissible to prove negligence, culpable conduct, a defect in a product or its design, or a need for a warning or instruction. So that's the explicit language of the rule. And as you can see, it's much more of a civil rule of evidence. There used to be a distinction in Texas between civil and criminal rules of evidence. Now we just have the Texas rules of evidence. They apply in both criminal and civil cases, but some are more specifically for civil cases. This is one of them. Now let's talk about the exceptions. And the rule language here is, but the court may admit this evidence for another purpose, such as impeachment, or if disputed, proving ownership, control, or the feasibility of precautionary measures. So when we're looking at this, let's think about the stair example again. If you argue at trial that you were doing everything you could at the time, you believe that there was nothing additional that you had to do, the plaintiff could say, well, you could have been salting the steps. Then as the owner, you can come back and say, well, I don't think that was necessary. We've never had anybody else fall. I think, there's some contributory negligence on the old woman. She wasn't using the handrail, whatever. You could say those things. But what you can't say is there's nothing at all that could have been done. There's no measure we could ever take that would make these stairs safer. If you say that, then you've got a feasibility issue. And you can then, as a plaintiff lawyer, say, well, yeah, there is something you could do. In fact, you're doing it. You're putting salt on the steps. The other thing you could use this for, you could use subsequent remedial measures, is to prove ownership or control. So let's say I own a field and I let it get overgrown and there's some snakes or something that come out of the field and they bite somebody and they want to sue me, the owner of the field, for not maintaining it and turning it into this, dangerous situation. Well, if one of my defenses is I don't own that field, I don't know what you're talking about, then to prove ownership of the field, if I then hire a company to go out and mow the field, that could show that I own it and that I have control over it. And so that would be a subsequent remedial measure, me mowing the field, but it could still be admissible if it is to prove that ownership or control. So it's always the exceptions that sort of make the rule. But this one is that basic public policy that says we want people to make these changes. And I think courts are going to be somewhat reluctant to admit evidence of subsequent remedial measures because they don't want to put businesses in this position where, oh, well, I can't make these changes because then a plaintiff might use it against me. One other thing to note here, if you do products liability, a manufacturer's written notification of a defect in their product can be used as evidence that the defect exists. So if you go to trial against Toyota, or let's use Ford, the Ford Pinto for as an example. You know, they used to, when you get rear-ended one of those, the gas tank was in the back and they used to blow up. Well, if Ford tries to claim there's nothing defective about that, well, the letter that they send out saying, "Hey, we have a defective product here," that can be used to prove the defect. And thanks for watching. This has been Texas Rule of Evidence 407. If you like what you saw, remember to like, subscribe. If you're a lawyer and you've used this rule in some interesting way, comment down in the comments and maybe we'll address that next time. And as always, these are for educational purposes only. If you need a lawyer, go talk with one. Thanks so much.